welcome. We're glad you're with us today. This is the Nuts and Bolts of Releases, which is episode 3 of the second series of Financial Poises, Nuts and Bolts on Chapter 11. You can read more about our series on slides 7 through 9. Our panelists today are, in alphabetical order, Matt Christensen of Johnson May, John Friedland of Mutt Schilst, and David Stein of Willens, Goldman, and Spitzer. I'm Matt Grimshaw. You can see our names on slide 6 and our bios on slides 36 through 39. This is not intended to be an infomercial, so you don't have to listen to me read our bios. You're capable of doing so. If you'd like more information about us, take a look at the applicable slides. Before we begin, we've got a couple of housekeeping matters to go over with you. First, I'll try to call your attention to slides that are relevant to what we're discussing at the time. You can take notes if you want, but if you're listening and can't look at the slides, don't worry. They are not an integral part of what we're discussing. Second, we have a big thanks to give to our co-producers, the National Law Review and Daily DAC. You can read more about them at the beginning of our slide deck. Third, Financial Poises webinars are supported by sponsors. The sponsor for today's webinar is Max Assets. You can read more about Max Assets on slide 4. Finally, the last housekeeping matter is a disclaimer. Although we are all lawyers, we are not your lawyers. You are not our clients. What we offer today is information for educational purposes. Nothing we say here today is intended for you to act upon without doing your own due diligence, including obtaining advice from someone that does in fact represent you if necessary. Without further ado then, how about we just jump right in? David, if it's okay, we'll begin with you and we'll be looking at slides 11 through 12. What's a third-party release in the context of a Chapter 11 plan?
Well, thank you first for having me here today, and I do appreciate the opportunity to speak. A third-party release in the context of a Chapter 11 plan refers to the provisions within the plan that extinguish claims held by or against non-debtor third parties. Those third parties could be shareholders, officers, directors, and other persons in control of the company or affiliated with the company. They could either be consensual or non-consensual, depending upon the circumstances of the case. The non-consensual third-party release would involve the involuntary extinguishment of a claim held against the non-debtor third party or another third party not within the control of the bankruptcy court.
And thank you for hitting that last point. We're going to talk a fair amount about those today. John, how do third-party releases differ from a standard discharge provision? I think this will help us further set the table for our discussions about non-consensual releases in a few minutes.
Sure. Before I answer that, could I just make a note about exculpation provisions?
Because of course, because they tie in, and I appreciate you doing that.
Well, thank you. So an exculpation provision is also a shield against lawsuits, but it's far more narrow than third-party releases. It doesn't release claims the way a third-party release does. It immunizes specific conduct during the bankruptcy case itself. You could think of it as usually the professionals of the estate, the debtor, the committee's professionals. It's basically saying, look, if we acted in good faith and did our jobs honestly, while trying to, reorganize the company, we shouldn't be second guessed later by the court. Typically covers things like negotiating the plan and making strategic decisions, carrying out court-approved transactions. It won't cover willful misconduct, gross negligence, bad faith. So it's a thing, but it's not, a third-party release.
So if I understand, the exculpation drives at the professionals of the estate. How does that differ from the standard discharge then?
So the the third-party releases, going back to your original question, how do third-party releases differ from standard discharge provisions? So the discharge under 1141D, it flows automatically, and it shields only the debtor. A third-party release affects non-debtors, and therefore it requires its own hook, its own statutory or equitable hook. And that requires a showing of necessity, fairness, consent. So that's how they differ from a standard debtor's discharge.
Okay. Matt, David started distinguishing between non-consensual and other types of releases. Can you just walk us through the difference between a consensual and non-consensual release of third parties?
I can, and at the risk of seeming too obvious, a consensual release is one that I consented to, and a non-consensual release is one I didn't consent to. Right? In a non-consensual situation, I most likely don't even get a chance to vote on whether I like that release language or not. In my mind, it's similar to like a cram down situation where I may not like the plan, but it's going to get approved anyway. And so a non-consensual release is similar to that. I didn't consent to it. Consensual releases, there's some method for me to consent, and that's a big debate topic as well that we may get into later. But in some fashion, I'm entitled to voice my opinion and be bound or not bound by that procedure.
Thanks. David, I know you started talking about this a little bit when I asked you last question, but just to try to finish tying this up, maybe one or two more questions, and then we'll just start jumping into Purdue, which is the case that we need to talk about today. The releases that have people animated, who are the beneficiaries of those? Who typically are the parties being benefited by them?
It usually comes down to who could be culpable in a reorganization. It could go to the directors, could be the officers, it could be the control group, it could be shareholders, it could be affiliates or parent-related companies. Usually, there's some identity of interest between the debtor and the third party. There may be control issues, or there may be parties who are the recipients of transfers that occurred within whether a statutory period under federal or under state law, and there's the potential for clawback or some other third-party liability.
Thank you. John, let's start setting the table for the Supreme Court's decision in Purdue, which slides 13 to 15. But in many ways it centers around third-party releases, and obviously the Purdue Pharma case was a mass tort case. Why are those sorts of releases, third-party releases, such a central issue in these mass tort cases, mass tort bankruptcies?
Well, one reason, I'm not sure if this is what you're fishing for, but if the debtor or debtors, they're usually insolvent, but affiliates are solvent, and other potential culpable or arguably culpable third parties are presumably solvent. So, and those non-debtors, they are often, the deal is often that they're going to contribute some substantial settlement dollars, but they're not going to do it unless they get peace too. The reason they would contribute value is to buy peace. So the getting the release or not getting the release will determine whether you've got third parties helping to fund, and that could make or break the funding of a trust, a victim's trust in the case where trust gets set up.
Perfect. And that is, I think, the reason why they are so critical.
I'm sorry, just wanted to add one other.
Please.
From a definitional perspective, it occurs to me that we haven't uttered the word. I don't think we've uttered the word injunction yet. We certainly
not
about it. So, at the risk again of stating the obvious, what's the relationship between a release and an injunction? That's a rhetorical question. I'll answer it. Or at least I'll try. They're two sides of the same coin, and that's all you really have to understand. The release is the substantive act. It's what eliminates someone's right to bring a claim against you. It's the enforcement mechanism. It's the court's order that bars someone from going after you. So in Chapter 11 plan nomenclature, when a Chapter 11 plan includes a third-party release, it's saying you no longer have the right to sue X, whoever got the release. But to make that effective, the plan also has to include, or should include, an injunction provision that says, and now everybody, you're prohibited from even trying to sue X, because without the injunction, the released party would still have to go to court and fight off each lawsuit individually. And the concept of the injunction flips that. So creditors aren't even supposed to bring a suit in the first place.
And thank you. When we get to some of the practical issues that are going to arise in dealing with the Supreme Court's decision, we're going to circle back to the importance of injunctions and how they can still help solve the problems that we're going to have to talk about. Matt, before the Purdue Pharma case, why was there confusion in the lower courts about non-consensual third-party releases?
I guess I would first differ with the term confusion.
Okay.
I think there wasn't necessarily confusion. There was just differing views on whether they were permitted or not.
How about inconsistency? Is that okay?
Inconsistency is a good word. Yes.
Okay.
So there were some circuits that had said, "Hey, these are fine." Other circuits had said, "These are not fine. You can't do them." Other circuits, I think the Ninth Circuit had said, "They're not fine, but maybe you could try this other little thing instead." And so there just was some inconsistency is a good word. The inconsistency between the circuits, which ultimately is why the Supreme Court decided to take the case. But that's what caused it.
All right, David. Let's talk about the three circuits that said, pre-Purdue Pharma, you don't get to do third-party releases. 5th, 9th, and 10th. Can you give us a quick, synopsis of their how they got there? What was their reasoning?
Yeah, but it's interesting when you look at the progression of the courts. So I'm looking at your slide. You have the second, which is the Southern District in New York, probably the initial court that heard the largest amount of business cases and morphed into the Third Circuit, which was Wilmington, and then somehow it found its way to Richmond, Virginia. Richmond fell out of favor because it was an adverse ruling. There was a retail case where the releases and discharges weren't necessarily recognized, and a lot of the courts or a lot of the practitioners found their way to Houston, which is the Fifth Circuit. Having said that, the Fifth Circuit split from the second, third, and fourth because of relying on the language of 524E of the bankruptcy code, which basically limits the discharge to the debtor and not to third parties unless found in some other provision of the bankruptcy code. And the only other provision was basically the discharge and channeling provisions related to asbestos or asbestosis type cases found under 524G, which implemented a trust provision, a liquidating trust provision with channeling and injunction provisions associated with that. So the courts in the Fifth Circuit, the Southern District of Texas, Houston, strictly construed the code and relied upon 524E to limit claims to just the debtor and not to third parties unless it was somehow found that the parties in the case explicitly agreed to it.
John, flipping to the other side, second, third, fourth, sixth, seventh, 11th circuits. In one sense or another, they allowed non-consensual releases. How'd the courts get there?
Pragmatism.
Okay, and that's a fair characterization. Is there a hook in the bankruptcy code they use?
105, baby.
I don't really know that there was one.
105 in combination with 1123B6.
Okay.
I suppose. But pragmatism is the word.
I think that is the best way to describe what the courts did. There's not a hook other than that. Matt, I know David alluded to it. There was, the differences in the circuits kind of created a forum for certain types of cases. Can you talk a little bit about the why folks were selecting venue? And I know David mentioned that this may have been one of the issues that drove a lot of cases to certain venues.
Yeah, and I think it's sort of a two-part question, like the venue selection and then major cases. So the tort claimants, they're looking for a party with big pockets, and so they're finding the big, huge corporation that's got a lot of assets and maybe huge insurance policies and that sort of thing. And so that's why the cases tend to be larger, because those are the targets for the tort claimants. You're not going to get a whole ton of tort claims being filed against this tiny little small business. It's not worth the effort. So you got these big cases with generally, large national companies or international companies. And each of those companies, and specifically the third parties that are seeking the releases, they want the release, right? And so you're looking at the circuit saying, well, if I go to one of these five, I'm in. I can get this approved. So you look at the venue selections or the venue clause of the bankruptcy code and say, okay, I need to open an office in the Fourth Circuit or the Second Circuit or whatever, and claim that as my home office, and I can go file a bankruptcy case. I think realistically in Purdue Pharma, that's exactly what they did. They picked a division of a district that only had one bankruptcy judge in that division, Judge Strain, and opened an office there and claimed that as their home office and filed it there, knowing it would get assigned to him. And so that's the Purdue case is a perfect example of sort of picking that forum that is going to be, I'll say, sympathetic and pragmatic towards the situation that you're in. It turned out there was a big enough fight that parties were willing to say, look, I don't care that you picked potentially the best circuit to file in. We're going to push this far enough that we'll ultimately get it reversed.
David, I know you mentioned the Southern District of Texas and how, that there's been this progression of cases away from some of the historic places, New York, Delaware, and then into Virginia, and now down to the Southern District of Texas. But I mean, I find the Southern District of Texas interesting because they didn't allow these sorts of non-consensual releases that seem to be at the heart of this. Any thoughts on why they were headed there in light of the inability to get a non-consensual release?
I just think that the court elevated its position to the bar such that it was looking for business cases, and it had certainty with how to handle them quickly and efficiently. And I guess the lawyers and the bankers seemed to think that was the best court to push through business cases at the time. It is actually ironic that granting of these third-party releases really is not the preferred route in the Southern District of Texas or the Fifth Circuit, but that's where the parties seem to flock to for the last couple of years, which I would say over the last 5 years.
And I agree. I found that very fascinating that they were getting away from the venues that traditionally allowed them. John, turning to slide 16, let's talk about the role that Purdue played in the opioid crisis. Can you kind of walk us through that, please? You're on mute, John.
Thank you. I was just singing songs to myself.
Sing to the rest of us.
So, how did it not, what way didn't it play a role? It was the biggest, baddest purveyor of Oxycontin with super aggressive marketing tactics, actually touting low risk to addiction issues. And it absolutely was central in sparking the opioid crisis. I could wax poetic. It played a huge role.
They being at the center, I guess that definitely is enough, and it's important to understand that. Matt, if I understand correctly, Purdue Pharma was it's a family-owned business, Sackler family. Can you talk us through the financial dealings the Sackler family had with the company before the filing in 2019?
Yeah, and some of this, I may get a little poetic too. By the time you got to the bankruptcy case, you were on like the third or fourth generation of family members that were owners of this company. And so the history of the company is an interesting topic all by itself. For decades, they had been around doing really a lot of good business and developing some very important pharmaceutical products that were distributed. And so from a sort of sociological perspective, it's interesting to me as you get to the third or fourth generation when some of the, we'll say, altruism of the original company owners has sort of worn off, and now you're dealing with the grandkids and the great-grandkids who are more in it for the money than the altruism, and maybe that played a role. But I think the OxyContin was first introduced in the mid to late 90s, and that's when sales really took off. At that point, the Sacklers were pulling out about 15% of the revenues every year in profits, which, 15% of several $1 billion is still a fairly large number. In 2007, there was a guilty plea by one of the affiliates to some false advertising of OxyContin. That guilty plea then led to a bunch of lawsuits starting to be filed. I think the Sacklers saw the writing on the wall at that point, so they started. The Supreme Court called it a milking program. Called it a milking the assets out of the company. So between 2008 and 2016, they pulled out about $11 billion in value from the company, which was, I think the Supreme Court estimated about 75% of the company's value was removed by the Sacklers during that time frame. So it was obviously much bigger than historically what they had pulled out. I think the milking program description is a good metaphor, and it left the company with virtually nothing to continue operating on or developing any sort of new products like they had done for decades. So that sort of dirtiness, I guess, is what really, I think, set a lot of the victims and the states and all the regulatory agencies off, was just watching this company get looted after they already knew those lawsuits were coming, is what soured people on the Sackler family, I think.
So we get a filing, David, in 2019, and Matt set the table, at least from a factual point of view. Kind of walk us through, if you would. The case gets filed, a plan is proposed. What did that plan propose to do vis-a-vis the Sacklers, and how does this all get set up?
Well, the Sacklers going into this and it came out through a discovery and litigation in the case, had pulled out about $11 billion of assets in the years preceding the bankruptcy. And the plan that was filed basically provided that the Sacklers would contribute to the plan funding approximately $4.3 billion. But that plan funding was to go over a period of 10 years. When you look at the calculations that were in the Supreme Court's opinion, you realize that somebody who lost their life could get or their family could get anywhere between $3,500 and $48,000 payable over a 10-year period. The various states, Indian tribes, and some other governmental units had objected to the plan. The bankruptcy court, in its wisdom at the time, I guess it was Judge Drain, determined that the plan created the best compromise and repatriated those assets without onward or continued litigation between the Sacklers. There was also the issue of having to repatriate those assets that were shifted overseas, I think, into Europe and other places. So the fair compromise was, at least in the judge's mind, to approve the plan to provide the Sacklers with a release under the plan and basically enjoin future litigation against the Sacklers by the opioid claimants. There were thousands. The Supreme Court reported that there were thousands of opioid claimants that objected to the plan. And the Supreme Court also reports that only about 20% of the victims actually voted in favor of the plan. So the court approved the plan, and then it was ultimately appealed.
Okay, thank you. We're going to jump back a little bit. John, David's really kind of set the stage for us, which is perfect, but can you talk briefly about the response to the release provision? Because as I understand it, the Sacklers were given a broad release. They get to keep all of the other money. They got $11 billion in roughly 8 years. They repay about a third of that. They keep the rest. Talk us through who objects and why, and how that worked out.
Well, as David said, there were a lot of objections. 9 states, DC, Indian tribes, several PI groups, the U.S. trustee making those statutory arguments in addition to the non-legal arguments in terms of how little some people would get. Congressional hearings, street protests, scathing editorials, basically, articulating that the plan would let billionaires buy their way out of accountability. There was a lot of negativity. On the other hand, there was definitely another strong stance, and not to jump the gun, but Justice Kavanaugh in his dissent, so I'm getting a little bit ahead of ourselves, he wrote something to the effect of, not only was the majority decision wrong on the law, which, it's questionable, but it's also devastating for more than 100,000 opioid victims and their families. And that the whole concept of Chapter 11 was designed to prevent a race to the courthouse. And that required bankruptcy court to have broad discretion to approve appropriate plan provisions under 1123B6. So there was a strong response in both directions, is the bottom line.
And you start going exactly where, let's have Matt kind of tell us procedurally what happened, and then we're going to have David start walking us through, the 1123 and how we get to where the Supreme Court, the majority ultimately got. And there are good arguments on both sides, as John started telling us.
So the bankruptcy plan got confirmed. The objecting parties were overruled. Judge Strain confirmed the plan. At that point, I think the plan had like a $4.5 million contribution from the Sacklers. So they appeal. The creditors and states and the UST appealed the confirmation order. They got a stay of the order on appeal. The district court, in a fairly quick decision, reversed and denied confirmation. And then the debtor appealed that. In the meantime, while that appeal to the Second Circuit was pending, the Sacklers agreed to contribute an additional about $1.5 million. So that's where you get to the $6 million contribution. That additional part got the states on board. So the states kind of withdrew their objections at that point, but you still had the creditors and the UST fighting it. Second Circuit ultimately reversed the district court, reinstated the confirmation order, but there was a dissent from one of the Second Circuit judges that very clearly outlined the circuit split that had developed and was a very good invitation to petition the Supreme Court to actually hear the case, which is ultimately what they did based on that circuit split.
David, why did the Supreme Court conclude non-consensual third-party releases exceed the bounds of the bankruptcy code?
Well, let me just start off. I'm just looking at the syllabus of the case. It's interesting that Judge Gorsuch wrote the opinion, and he basically split with Judge Kavanaugh. They're usually aligned on a lot of issues, and Kavanaugh wrote the dissent. But the bottom line is that the court relied upon the language of 1123 of the Bankruptcy Code. In that provision under 1123, I think you look at the title of it, it's contents of a plan, and contents of a plan really affect the assets and liabilities of the debtor before the bankruptcy court. And they used a phrase, now I'm not great on Latin, as judem generis, which basically is in the same context, if I interpret that correctly. So when you look at 1123 and the provisions that the court looked at in 1123B6, focusing on include any other appropriate provision not inconsistent with the applicable provisions of this title, they looked at the provisions of the title or the subsection of the title, which was under B1 through 5, and that affected class of claims of the debtor. It affected item 2, which was a rejection or modification of executory contracts. Section 3 concerned adjustment of a settlement or adjustment of claims against the debtor or the estate. Section 4 concerned the sale of asset or property of the estate. And 5 was a provision which sought to modify claims. So when the Supreme Court looked at the catch-all provision, it basically found that it had to be in the context of how the debtor is being treated under the plan, not what other creditors could seek by virtue of this third-party release or third-party injunction, if you will, and it really limited the relief under the bankruptcy code, under the content section, to those rights affecting the debtor, the debtor's assets, and the debtor's estate.
That then, and I'm just going to throw this out to both John and Matt, because that ends up having some fairly significant implications. What are the practical takeaways? I mean, we now know that you've got to focus on, from 1123B, what a plan. The 1123A says it's got to do some things. 1123B says it can do some things. When you talk about what it can do, and if you have to focus the way the Supreme Court says that we do on claims against and by the estate, what are the practical takeaways now for how we deal with stuff? And John, Matt, you guys decide who wants to start. I don't care.
John can start.
Okay.
I'll just point out that, if we're talking about, I mean, we're not here to revisit whether the Supreme Court got it right or wrong.
Exactly.
But as we focus on the language of 1123B and to use the doctrine of the justim generis, it seems like a mistake on the face of it, because in B1 through 5, Congress knew it wanted to use the words to the debtor or the estate in B1 through 5. Congress chose not to use those words in B6. So I'm not so sure that Kavanaugh was wrong, but in any event, the practical takeaways, well, debtors have to secure consent. They've got to ask for and get consent if they want to include third-party releases, or lawyers can help create alternative vehicles, maybe pre-petition settlements, but you can't rely anymore on being able to get a non-consensual release. I'm not sure if you're looking for something more than that, but that's the biggest practical takeaway.
No, I'm looking for exactly what you gave us, and that is, what are the practical takeaways that we get from your point of view, Matt? Do yours differ? What's your takeaway from this?
No, the biggest one's just that you don't get a non-consensual release. Period. I think one of the practical effects of that is there's going to be less of the type of forum shopping that you saw before, because it doesn't matter what circuit you're in now, you can't do a non-consensual release. But what we may see more of is forum shopping based on the type of consensual release that the different circuits may approve or sign off on. So there may still be forum shopping moving forward. It's just going to be a different form, and probably to a lesser extent than you would see before with full releases being allowed.
David, you talk about how Justice Gorsuch and Justice Kavanaugh kind of split on this one, and I agree with you. That's an interesting. It's interesting the way it came out. I think Justice Gorsuch's last paragraph, I find it pretty interesting, because he lists some things that they are expressly not addressing. Why aren't they addressing? I mean, they talk about not addressing third-party or consensual releases. How do we deal with those?
I think you deal with consensual releases as you've always dealt with them. It's part of a business plan or arrangement authorized and permitted under the bankruptcy code. Parties are always free to shape settlements, releases, compromises in the context of doing business, or in the context of a negotiation during the proceeding. And I don't think he was ruling against that because or arguing against that, because at the end of the day, that's a normal ebb and flow in all bankruptcies, the ability to compromise or settle claims, and that would not be appropriate to take that right away.
John, if we're talking about consensual releases, I guess the cornerstone of that is what is consent? I mean, what qualifies in this context of what a consensual third-party release is?
That's really going to, be one of these begs the question type of issues. And I agree, it will, form shopping will still happen. It'll just happen over, a different issue. To state the obvious, or maybe to, so your question is what qualifies as consent? I'm thinking in other contexts other than law. When have I consented to something? I've got to affirmatively, with the proper information, agree. That would be, I think, qualification as consent. So checking an opt-in box, signing a settlement agreement, otherwise clearly accepting the provision providing for the release, having had received conspicuous notice. I mean, that is, I think it's fair to say, the lens through which a court should analyze the question.
So we're looking at whether somebody actually understands now what what it is they're agreeing to. Is that your view?
Well, I mean, sure, but all that means is the relevant language needs to be in plain English, and it's not. I don't think it would. I'm suggesting a change of practice is necessary. I'm describing what already is better practice.
And that I think is the key. Is one of the takeaways is we've got to make sure that we're using best practices, because we're going to talk about for some very interesting ways that courts are starting to deal with this, or lawyers are starting to deal with it. And John, you mentioned one, opt-in. So maybe we can have Matt tell us what this opt-in structure is and how it works.
I can address that. I want to go back to what John was just talking about real quick first. So,
please.
I mean, I think there's a difference between consent and informed consent. And there's nothing in the Supreme Court's opinion that addresses informed consent, which what Jonathan was talking about to me sounds more like informed consent, right? Like I have to be told exactly what I'm consenting to, make sure there's sufficient information that I understand the consequences of consenting, that sort of thing. So from a best practices standpoint, I completely agree with what John said. It's important to make sure people understand what it is they're consenting to. But from a what's required to constitute consent, I don't think that sort of information is strictly required. I think it heads off some potential arguments later to say, look, you knew what you were consenting to and you consented to it. But I think there's a distinction there that should be recognized.
I think it's probably a distinction without much of a difference, even though the analysis might not be made under Purdue. I mean, you're really begging the question of, is the disclosure statement adequate? You shouldn't even get past the disclosure statement phase if it's not clear.
You're not describing what they're consenting to. I don't disagree. I think it's an argument of the disclosure statement, though, more than was their consent informed when they got to ultimately voting on the plan. And from an opt-in standpoint, that's generally how you see the opt-in consent happen. Is, you'll have a ballot that says, are you for or against the plan? Whether you're for or against the plan, or do you opt into this release provision or not? And someone has to affirmatively check that box. So it's effective for people who have to submit ballots. But you always have certain classes in plans that don't get to submit ballots. And so if there's no other method created for those people to opt into the plan, then you're relying on you've got a logistical issue where you've got to send in like an opt-in form to those people and have them check some sort of box. Otherwise, you're left with them not actually consenting.
David, if we're talking about, you have to check a box to consent. From a practical point of view, how does that work in a mass tort case?
Well, I think in any case, there may be a separate opt-in, opt-out type of ballot or questionnaire that you're going to fill out. But I think the courts generally agree that the language has to be clear, conspicuous, and provide some type of affirmative election process. On a mass tort case, it might be easier for you the way you think about it, because these cases have built up over a period of years. You're dealing with class counsel, you're dealing with lead counsel, you're dealing with large groups of organized claimants, and it might be easier to get something like that through. I'm not suggesting they're going to jump on board, but at least you're dealing with an organized group of people who are representative of the class of claimants. So that might be an easier road. But at the end of the day, it really comes down to notice, whether the language in the release is conspicuous, whether it affords the parties adequate and due process so they have the affirmative right to either accept the treatment or not. So that's how I think it would work in concept.
So in your mind, then, David, you think maybe in a mass tort case, it might be a little easier than if you simply had a case with a larger creditor body and you don't have individuals acting on behalf of large groups?
Yeah, I mean, it's hard to generalize, but I would think in the larger mass tort case that's been percolating for like 5, 6, 8, 10 years, and I'm not suggesting that that's the road in J&J, because it's certainly gone on to 3 different cases. But if you had maybe another scenario, maybe if it was a drug case, a Dalcon Shield case, something going back in time where there was an organized group of plaintiffs, and you could sit down and explain it. They were involved in the disclosure and solicitation process. It might be easier to get something like that through a mass tort case.
I have a question. It's a question in the form of a comment, I guess, because I'm not allowed to ask questions. I'm not the moderator.
Look, I abdicate for a few moments, John. Please, let's have
It'll be chaos.
I'm fascinated by this concept. David's maybe onto something, because I actually have another question for him after his comment, but go ahead.
So yeah, I was just hypothesizing to myself, what if you've got a situation with a mass tort and, let's say the 150,000 known victims, that, like the 80-20 rule, 80% of them are represented by, pick a number,
a handful.
13 law firms.
Sure.
And if those law firms in their engagement agreements, have been given limited powers of attorney to vote, to agree to, on a plan, including to agree to opt in or not opt in. Is that a thing? Does that even pass the ethics? Ethically, do you even forget bankruptcy? Do you even get past the ethical question of whether a lawyer's engagement agreement can give the lawyer that kind of power of attorney? I don't know. Thoughts?
Well, you're assuming that they haven't communicated with their clients, and certainly if you're going to sign off as a lawyer on a settlement or on a opt-in or opt-out or whatever, I'm assuming you're going to send it to your client and ask for permission or approval as like any other settlement.
What if up front you kind of anticipated that you might end up in bankruptcy, and you anticipated all this, you anticipated well, and you put in your engagement letter that should there be a bankruptcy, should there be a Chapter 11 plan, that the decision to whether to vote in favor or against, and the decision to vote of confirmation, and the decision to vote in favor to opt in or not opt in into a release, those decisions are, delegated to the attorney.
Then I think, and if this is directed to me, I think it might be an RPC type issue, whether you're foisting your own interest over the interest of the client. I think it really goes back to the attorney-client relationship, and that there's been that the client has been adequately informed and makes a full and fair decision whether to settle or to reject the claim. I don't know if the bankruptcy court is going to get into that level of scrutiny, other than looking at the disclosure or the ballot, the claims to determine whether or not there's been adequate voting based on that class of creditors. But at the end of the day, that's really a determination between the lawyer and the client.
I think I'd echo that. I think whether or not to consent to a release, to me, is basically a settlement decision, which my recollection of the professional conduct rules is settlement decisions are always the clients to make, not the attorneys. I may have that wrong, but I don't think the bankruptcy court would care who actually makes the vote. That it's an attorney-client problem if that gets delegated.
And how would you know at the beginning of the engagement what the range of settlement is, and how would that then be delegated to the lawyer to make that decision? I don't think you would know and be able to predict what's on the table and whether or not you are then empowered with the decision as a lawyer whether to settle the case without the input of the client. 6 months or 2 years later, it would not be appropriate. But really, again, that falls between the attorney-client relationship between the claimant and their lawyer.
So we probably don't get past first base. We don't get past the state law, the state issue of professional responsibility, probably.
And that may be the case because of the settlement issues. But I've got another question that kind of, just came to me while you guys were talking about this, and that is, does this idea that it may be easier to deal with a few representatives than a whole horde of folks, does that then give debtors counsel an incentive to wait as opposed to filing early when you see potential problems coming down the road? Does that give them an incentive to wait until you have a certified class and things really get moving in the class action before you move the entire thing to bankruptcy court as part of a restructuring, so that it is easier to start dealing with these issues on a mass level?
I don't know, but you made me think of something, which is the distinction between class actions on the one hand and mass tort litigation that is not a class action.
And that's a fair point.
And it's a huge distinction, right? Most or all of the asbestos cases were not the great, the significant, well-known asbestos cases were not class actions. they were just 10,000 or 100,000 individual lawsuits, which is what really necessitated these companies filing respective filings, because they were taking a cut by 100,000 stabs.
Right.
Anyway, I digress.
And we don't have answers. It's just going to be interesting to see how this plays out. So we talked about opt-in. Maybe we talk quickly about the other two sorts of consent that we started to see out of courts: opt-out and de facto. Matt, can you talk to us for a minute about what opt-out consent looks like and how is it structured?
So it's obviously the opposite of opt-in. With opt-in, I'm affirmatively saying I want to be bound by that. Opt-out is I'm affirmatively filing something saying I'm not going to be bound by this release. Same sort of way, if you've got a voting class and there's a ballot, on the ballot you include some provision where they can check a box to say I'm opting out of that release provision. For non-voting classes, so classes that don't return a ballot, they would need to file some sort of objection or something in a different sort of form to opt out of it. And then you also have the issue in that case of voting creditors that are entitled to vote but don't. And so is there sort of an implied opt-out or are they impliedly opting in by not returning a ballot that has the opt-out clause? And that's probably one of the more recent struggles the courts have started to have, was, for those parties that don't return a vote but are entitled to, are they going to be bound by this when they didn't return anything?
David, what advantages or pitfalls do you see in the complex cases with an opt-out provision?
Well, I think it creates some confusion because you're sending out 10,000 solicitation packages, and you're affirmatively telling these parties, or you're affirmatively telling the parties that unless they agree to, let me try it again. You're affirmatively telling them that they have to affirmatively object, otherwise they're bound to the plan. I think it creates confusion, and I think you saw it in the Southern District about 10 years ago on some of these insolvent Chapter 11s, where it bound the administrative claimants to plans that, on a fair reading, they would not necessarily have agreed to go along with. I just think it's really not necessarily, well, I don't want to inject my personal opinion. I just, you have to act affirmatively to opt out.
John, real quick, can you, I mean, are courts allowing opt-out, or how are they dealing with it?
Well, the courts, the decisions I'm aware of, no. I think judges Jernigan and Jones have refused to enforce opt-outs post Purdue. I know there's those cases also out of the Northern District of Texas. They both start with Ebix and Iger, right? Where one stated an opt-out is impermissible, the other stated an opt-out is permissible, but and both plans were ultimately confirmed because the court determined that the release was consensual in nature. So that's some evidence that the ability to have an opt-out is alive and well somewhere in some places.
Let's, as we're running out of time, let's quickly turn to de facto and talk about de facto consent. David, do you want to tell us how that works real quick, and then we'll try to wrap this up?
Yeah, sure. I think de facto consents are typically found under 1191 of the Bankruptcy Code, which is the which is a subchapter 5 provision under the code. It allows where creditors are deemed to have accepted the plan without either voting or objecting. They need not take any further action, and their consents are conferred by the fact that they were served, that there was adequate notice, and that they're treated under the plan. There's nothing further that they have to do. Basically, just being provided with notice.
Matt, any thoughts on how this ties into perhaps creditors that get paid in full, but down the road somebody else might pop up that wasn't paid or wasn't even notified?
I think there's always going to be notice issues and consent issues with creditors that weren't notified, right? If I had an unmatured claim or something along those lines, I wasn't listed as a creditor for whatever reason, never got a copy of the plan, didn't get a chance to come in and opt in or opt out. I think it'll be difficult for a court to say that, notwithstanding that 1191 says I'm bound by that plan that I didn't even know about and never had a chance to voice an opinion on. At some point, you're getting into due process and notice issues that you just can't overcome.
That's interesting because it kind of it edges right up against the question of what's a claim and what's not a claim. Does someone only, a future claimant versus a present claimant whose claim is merely contingent, and whether, publication notice in, say, the National Law Review or some other publications can serve as adequate notice for holders of contingent claims. And again, it'll beg the question of what's the line between a contingent claim and somebody that does not yet have a claim because it's a future claim.
And John, I agree with you. I think there is an entire program's worth of materials that has to go into what is a claim and what type of notice is adequate if you're going to try to eliminate a future claim along the lines that they're now trying to do, because it is a very interesting place to find yourself. One final question for each of you. It's the same question. Best practices as we move into a post-Purdue world and we're drafting plans. What are your thoughts on best practices and how to try to achieve what it is that, from what John alluded to as a practical point of view, and going back to what Justice Kavanaugh said in his dissent, there are some real practicalities for why these sorts of provisions need to be achievable in very big cases. Is there still a way to do it post Purdue? And I guess maybe just in alphabetical order. So Matt, then John, then David, and then I will say one final thank you for everybody showing up. Matt?
I guess we're going alphabetical order by last name. Otherwise, it's reverse alphabetical order.
Yeah, we'll go by last name.
Sure. Either way is fine. I think my big takeaway is the last paragraph of Justice Gorsuch's opinion, right? What this does not apply to. So it doesn't apply to consensual releases. That's already an issue. It doesn't apply to plans that provide a full satisfaction of claims against a third-party non-debtor. So arguably, you could still have a non-consensual release if the plan is a 100% payment plan. And of course, then does the plan get confirmed, and then does it get performed, and are there issues with that? This opinion has nothing to do with that. And then lastly, of course, he says, look, this opinion does not address whether it can be used to unwind plans that have already been confirmed. And that's a whole different issue. So I think that last paragraph is important of what's not covered.
Thanks. John?
Well, I think that in situations where third-party releases are a critical goal of the filing, if you're small enough and you can fit into subchapter 5, you've got a pathway. If you're huge, that's where you probably have the ability to get creative and look to state law contract rights, and looking to a bankruptcy court to simply enforce a contract entered into under state law, because that's okay. That's not touched by Purdue. But then there's the vast middle where you don't fit into sub 5, and there's not enough total dollars at stake, and therefore not enough of a legal budget to run the case, run the situation through a process that can pragmatically work. It'll be interesting to see if Congress. It wouldn't be the first time Congress has passed a law to undo the result of a Supreme Court case.
That's an interesting thought. And just to clarify, on when you said by state law, you mean just large releases and relying on state law to enforce them?
Yeah, private contract.
Okay. David?
Well, I think picking up on what John said, I think it leads to more potential pre-packs in terms of negotiating with creditors going into the case, so that you have a sufficient number and a majority of the creditors going in, and you can lock up those creditors, ensure that going into the case that there's some certainty that you're going to get the same result that you expected when you filed the case. So certainty of result may lead to more pre-packs and negotiations with these creditor groups, whether in a mass tort scenario or some other case where you've got a multitude of creditor claims.
Matt, John, David, thank you for helping today, for your participation. Thank you to everyone for being here with us. And a final thank you to our sponsors and others involved in putting this all together. We're done.
Thank you.
Thank you.